was enjoined from being implemented because it was a prohibition against using arbitration clauses, and the court said that the federal government was not allowed to do that. Now, when the Trump administration took over, they pulled that rule and made a new proposal. They said that facilities could use pre-dispute binding arbitration clauses in their contracts if they were in plain language, if it was a condition to be admitted to the facility, the language.
We've been able to foster an environment that has attracted other folks as we have looked out in the community for people who can work with us. And again, we find in our elder law practice that I don't know that it's easier, but that the client staff bonds are stronger than what we see from the folks that aren't part of the silver tsunami.
We're going to talk about tools you can use in your practice, how to take a look at your marketing, how to look at your digital footprint, so your presence on the internet, and see if you're taking steps that actually make someone more likely to hack you. So we're going to talk about that as well. We're going to talk about how to hire an IT consultant. As a show of hands, does everyone right now have an IT consultant for their practice? Pretty much everyone? Okay. Or at least has an idea of who they would call if there's a crisis. Okay. So we're going to talk about how to hire that IT consultant, make sure that they're on call for you. And we'll also talk about the basics of cyber insurance. So getting started with cyber insurance, how to understand how to purchase it for your practice. Should it be a rider? Should it be a completely separate policy? And then how does it
actually... There are my exhibits. Then the next thing you do is you look at the rules and the statutes. Everything has a statute anymore. So you look at the statutes, you look at the negligence per se. Obviously, if you've got a rule or a statute, you could have a negligence per se. You have a strict liability statute. You look at your definitions in the statutes. Then you identify their purpose of the litigation. Other than to assuage somebody's hurt emotions, where are we going? What do you want to get from this outcome? And it cannot be the principle of the thing. There must be some money, okay? It can't be the principle. So you have to know, where are we really going? Because this is not for the faint of heart.
In Florida, we already have the fiduciary duty. It exists as a matter of common law in Florida. There is state law. There is an 11th Circuit case called Goshnauer. Failure to diversify, churning, which is essentially excessive trading, or in and out, in and out, in and out for the purpose of generating commissions. And there are certain indicia turnover ratios and cost to equity ratios that we calculate to figure out whether or not the account was churned. Occasionally, I get lucky and I'll find a broker who was unregistered. That gives me an automatic strict liability claim under our belief.
What might you as an attorney do to assist in exploitation? Well, the first one that we see is we see documents being drafted by an attorney for non-clients, most often that they don't see. We also see people who have pushed print from Google and given documents to somebody. You know, a really sweet person who works in a rural doctor's office gives the daughter a power of attorney and healthcare document that she found on Google, and mom needs a power of attorney because she's got late-stage dementia. So here you go, daughter, why don't you get mom to sign this? Drafting documents for clients when a third party has directed them. So your client comes to you, and this can happen in a variety of ways. I sometimes get calls from kids who want to bring mom and dad in for documents, and they want to tell us what the
defendant reasonably have known that the victim lacked capacity to consent. And this is one of the hardest crimes to prove. It is probably easier to prove a murder, which we used to say at the state attorney's office, it's a battery with a bullet. Okay, this is different than regular theft. Why? because you probably have a victim who can't testify or who can't give meaningful testimony or who you'd be afraid to put up on the stand because you just do not know what they will say. And my old supervisor and I had a case, it was a terrible case, where a gentleman was in a hospital, and while he was in the hospital, his lease expired in his apartment, and he was discharged and he had nowhere to go.
But this is, more so than hurricanes and more so than text, this is one of the biggest challenges we hear attorneys on a weekly basis share. Not necessarily that a signature is missing, I think that's an extreme example, but something fell through the cracks that week, and they're doing a crisis management because something that was routine escalated to something that was out of control. So as you think about creating your office manual and your playbook, how do we put that together to eliminate the crises, to make sure that everything is running smoothly? Okay. But is it all about communication? I really do think a lot of it is about...
That's not the answer that I want. I want to know what it is exactly that we are asking the court to do. And so we will discuss that today, what our toolbox is when filing an adult protective services action. There are some ethical issues. I think especially those of you who are involved in representing vulnerable adults in these actions, I think that it raises a lot of questions of what is it that you do for a client who lacks capacity. So we will discuss
about 1,000 points where every lawyer who represents a professional guardian and every professional guardian ought to cringe. It essentially says, if you do your job and you do what the statute wants you to do, you must be a horrible and evil person. I highlighted a whole bunch of points going through it that draw me great confusion, how the press can put these things out and talk about us and talk about what our client guardians do and what we do for elderly people without recognizing how insane the logic of what they say is. The first gentleman that was anecdotally described was too confused to argue about the guardianship process, which, I'm sorry, to me suggests in no uncertain terms he very likely needs to have a guardian.
Medicaid planning, if you make a mistake, what are your damages? How many of you have thought about that? 2, 3 people? Well, if you do any kind of Medicaid planning, you need to be able to know what your damages would be if you mess up. Because you may have to end up paying for home health care in somebody's house. You may end up having to pay back nursing.